November 18th, 2017. My name is Kuldip Randhawa. I live in Surrey, BC, British Columbia, a province of Canada, a nation that's considered at the forefront of human rights. I have placed a number of videos on YouTube concerning various frauds that are taking place within the court system and in BC by a number of organizations. I have written to Parliament a number of times. The last time I recall sending a affidavit which was quite extensive, close to 1.5 inches thick if you were to print it. It included most of the evidence that they needed to commence an investigation of BC organizations. The reason for making this video, after seeing the other videos, you will see that what I'm trying to do here is to educate the public and reach out to everyone in Canada with a possible solution so that we can solve this major problem that's taking place, which I have actually titled as Crime Houses of British Columbia, which is similar to a problem that we all know about, residential schools. Because when these problems occur and they carry on, they always start for a reason, and those reasons are all often concealed and not discussed. And so when you start to conceal a problem, the problem is not going to be before the public, and it's not going to be solved. And so the problem becomes quite extensive. So I take no pleasure in doing this, but I see it as my duty. As a person who is resident in Surrey, BC, I feel that someone has to take the step to alert the public and perhaps reach out to a number of justices, lawmakers, politicians, and even the law enforcing agencies. So the first issue that I would discuss, and there's about 10 points I would like to make, and all of these 10 points concern a way in which we can alert the public what the problem is and perhaps find a solution. I don't have the answers to all of the problems currently. What I'm talking about is a difficult situation that I'm in. If I could go to a courtroom and tell the judge that there's a problem, I would do that. In fact, I have done that. Only to find that I was actually arrested on that day, on June 8th, 2017. If the justices had done their part in a particular proceeding, perhaps these videos would not have gone on online. But I feel that this matter has to be disclosed to the public so the problem can be solved. So what are these 10 points? The first is oath of allegiance. Whenever a politician or citizen of this nation, or a police officer, or some minister, everyone takes an oath of allegiance. In the United States, it's no different, and the oath is normally taken by placing one hand on the Bible and reading a statement. And that statement sometimes is different and is modified, but the essence of the statement is that one has to be loyal to the Queen and to not abuse the laws of a nation. Take, for example, John Quincy Adams, the 6th President of the United States. He placed his hand on a law book because in his way he was following the Constitution as opposed to putting his hand on a Bible. Take also the current President of the United States, Donald Trump. He placed his hand on 2 Bibles. In essence, the meaning of taking an oath is one has to be honorable, one has to follow the law, and essentially not to mislead the public. In taking that oath, there is a certain level of responsibility that is not shared amongst other people who have given a certain duty. In Canada, a politician will also take an oath of allegiance. And in taking that oath, after taking it, the person can then receive the salary of the post, of the position, or the office. If you don't take the oath, you don't take any money from the government. There's no salary involved. But that oath is always about ensuring that one will fulfill the office. And a judge, for example, has an oath of office. There's lawyers who are officers of the court. They are bound to follow the law. It's never the case that a lawyer can go to court and deceive the court. That never is allowed. But when it does occur, the problem is always concealed. And so this is one of the reasons why I've exhausted all my remedies of actually writing to numerous organizations, writing to the Chief Justice on numerous occasions. And I feel that I'm just saying a message on deaf ears. It doesn't get heard. And so this is the first step, that we have to understand that when a politician or minister has not fulfilled the function of the office, then they have actually breached the promise that is actually made to the Queen. And therefore the salary should not be taken by that person from the time that the breach has occurred to the present day, or until that person is removed from office. Because when that happens, it's not only the fact that you are being paid to not follow the law, but you are actually breaking the law and causing harm to other people that come before the politician or the judge. And so there's separate damages awarded to people who are victimized by such individuals. And so that is the first step, that one must understand and recognize that in a nation such as Canada, if you do not act appropriately and you do not follow the oath of allegiance, then you are actually affecting the reputation of Her Majesty the Queen. So Her Majesty the Queen has a duty to correct this problem, which is the next point that I would make. So number 2 is the Queen, as the head of state of Canada, has the ultimate duty to ensure that the oath that is taken is not simply some statement that is read as part of a ceremony. It has to have some meaning. If the person takes an oath and breaches it and breaks the law, then what value does the oath of allegiance have on that politician or the justice who's taken the oath of office? It has no value if you're not going to enforce a problem that has occurred, because now you have a politician that has not followed through. And so it affects the reputation of Her Majesty the Queen. As a British citizen who is living here in Canada, I have that right. Every citizen of Canada, when they take an oath to become a citizen of Canada, they are actually taking the same oath of allegiance to the Queen, even though that statement that is read is slightly different, because it's now varied, because it's applying to Canada as opposed to one that is applying to the United Kingdom. But the essence is the same. And so when that happens, I'm doing my part by protecting the monarchy from misrepresentation. And I can only do so much. I don't have the powers, I don't have the abilities to enforce the law here, because I'm not part of the police force. I'm not a police officer, and neither am I a judge of the court. If I were, I think justice will be done very swiftly and very quickly. But I can't talk about that because I'm just a normal person trying to make a living in Canada. I'm trying to follow the oath that I gave to Her Majesty the Queen in protecting her name, that she must act very quickly. It's not the case that progress is not being made in Canada. There is progress being made, but it's so slow. And some of the progress that is made is then reversed, which one will see after the complete video is presented to you. So I'm appealing to Her Majesty the Queen. I can only do so much here. I have written to Buckingham Palace. It seems that what is really happening here is the public is being deceived, and also Her Majesty the Queen is being deceived. And so I'm appealing to the Attorney General of Canada. Her Majesty the Queen has elected you for a purpose. You have a higher duty than me to protect the reputation of the Queen, so that people who are suffering here don't need to suffer more than they need to. Because the progress that's being made is often undone. And so we have to make swift changes in order for Canada to be truly considered at the forefront of human rights. So at a world level, then we can make a world a better place. Because if we don't do that, then no one needs to listen to Canada either. It's not written somewhere that a person can be abused and discriminated against, and that he has to openly go and continue and praise that nation. The First Nations, the residential schools. If you really want to have a discussion of what pain and suffering is, you only need to talk to these individuals that have suffered immensely. And I really believe that with that exposure, some change was coming about. And I think it has come about. But for it to be enforced, one has to act quickly so that we can take care of this problem, so it doesn't occur more than it needs to. And so, in order to bring justice for people who have suffered immensely within the court system, we have to now go on to the next point, which is instruments of fraud. What is an instrument of fraud? It is actually a document that has been prepared. It could be an action, or pleading, or it could be an order, or it could be a determination. Often one signs this document. And when a person, whether it's a justice, whether it's a panel of 3 engineers at APEC BC, or whether it's a master who has limited jurisdiction often to not hear matters that ought to be before a judge. So where does one go when there is actually a judge in the court who is not intending to give any justice? Does one have to then go to the Chief Justice? Which is kind of what I have done on numerous occasions, have written letters to numerous Chief Justices and alerting them to the fact that the judges of the British Columbia Supreme Court are not acting according to law. They have breached their oath of office, and so therefore they need to be investigated or removed from the case. And so what happens? An instrument of fraud is actually a document where fraud has occurred, and that fraud can easily be assessed by looking at the proceedings that have taken place, which are all recorded, and look at the facts, look at the merits, and then compare that to the order that has been made. Compare that to the determination that has been issued and then posted, in which a reputation of an engineer has now been defamed, not only in Canada, but all over the world. Because that is now posted. Because they want to protect public safety, for example. We have a process where the determination is posted. Consider the APEC BC fraud, which I have actually put on YouTube. Am I really supposed to accept that determination when I know the fraud has taken place? The Code of Ethics applies to me. It applies to every professional engineer. I cannot accept a fraud under the Code of Ethics, which is within the Engineers Act and the bylaws that exist. A person who knows that a fraud is taking place or where public safety has been affected, he has a duty to report that matter or that organization. That is exactly what I have done. I've actually reported APEC BC, the same organization that is supposed to enforce ethics and discipline professional engineers. They have involved themselves in criminal offenses here. I cannot accept that determination and say that a water tank that has no water pipes to fill it or empty it is a water pipe or is a tank. It is not a water tank. It's not a structure that was for storage. When you have a structure that's been built which has no water pipes and it's not a water tank, then technically speaking, it's what I've termed in my book absolute privilege to deprive as an object of fraud. Very similar to an instrument of fraud, but it's actually a physical structure that has been erected to appear as a water tank when it's not. To set up an engineer, or to pass the blame of another engineer of another tank that actually did fail, but it wasn't not this one that was the subject of the discipline proceedings. That is not what the Court of Appeal is for in going to the Supreme Court of British Columbia, for example. There is a process where a person can appeal that matter. My experiences have been that a number of lawyers that I've approached in preparing the appeal, they do not want to talk about the fraud. They want to dismiss this as some kind of error that has taken place, where some analysis has not been done, which is what the approach was taken by one of the lawyers, Mr. Soroso. And John Piemonte, when he prepared his appeal document, he also stated that the matters about the fraud are not going to be discussed here. So if lawyers are told, instructed, and the Law Society of British Columbia are told and instructed by the powers above, someone who is behind some desk, some office, whose name you will never know because he's working behind the scenes, and that person has told them, do not investigate the fraud. It doesn't matter to these people that a person's reputation has been ruined and now a person has been picked upon because he belongs to a Sikh community, an ethnic community, who is not going to be represented by the Sikhs within that community, or the leaders are going to be silent. This is not who Sikhs are. So essentially speaking, how does one explore these problems? You simply look at the order and you prove that this order is an instrument of fraud, and therefore that is grounds for a retrial. But before the retrial is done, those people who have entered that order with the knowledge of the fraud have to be held accountable. And there's numerous ways of doing that. One, I would say, is I'm appealing to the Right Honourable Justin Trudeau. We have a engineering institution here, APEC BC, that has done fraud, and they have done it close to 20 years, at least. I think the Engineers Act is clear enough that any engineer can be disciplined. Some of the changes that are taking place recently are that engineers within the association themselves who are given the duty to regulate the profession can also be disciplined. Well, that is pretty obvious. It's always been there. It's just no one has exercised it yet. Normally, professional engineers from the ethnic group do not want to file a complaint against professional engineers, so that right is always there. So simply making that change is a very minor change. What needs to happen is the people who have committed the fraud have to be punished, sentenced, and fined, and held in contempt of court for allowing fraudulent proceedings to continue. And rather than investigate it, the crime then continues the next day and the next day and so forth. Under law, a crime that's committed one day and continued the next day is a separate offense. So the punishment should be according to that. So the next point I would like to make is this. that when abuse of process, due process, and intimidation is the next point. It's a long title, but it's intended to cover a wide range of problems that occur when a person decides to go to court and complain about this matter. He may complain to the registry. In Vancouver Courts, there's a filing process that one has to go through. When those applications are refused for filing, that is basically a means to deny justice. And so when the complaint is made, that person who has refused filing has to be held accountable and investigated. And so the sheriffs, for example, when they prevent you from entering the courtroom and they're told that Mr. Randhawa now has to be searched illegally because he's some kind of a threat when actually he's not. They simply state it as such. Because I've not really ever been in a situation where I've attacked anyone in court. To the contrary, I have been attacked. I've never seen a lawyer who's done fraud ever being searched. So a self-representing litigant who has not really done anything wrong should not be searched. That's intimidation. And when you have a court system where there's so much fraud taking place that some of the justices of the court will have you arrested for speaking the truth, well then where does one draw the line? What if some sheriff has been told, well, let's plant some weapon on Mr. Randhawa when he's being searched, and then they'll tag me as some kind of a criminal when I'm not, and then the public's not going to speak out because the media's not going to speak out. When you call the police, RCMP or the Vancouver police, who are supposed to turn up because I want to report a crime, which is exactly what I wanted to do on June 8th, 2017 in Westminster when I appeared before Judge Murray. I was actually arrested. I requested a stay of proceedings so I could call 911 in the courtroom. So I took my phone up. And that's when the sheriffs actually took me down. I refused to accept that there was a proceeding before the court on that day that actually was not before the court. It was not on the trial list. The only application that was before the court, and bearing in mind that this is the first application before Judge Murray, it was supposed to be a case planning conference. And my application in the proceeding S123329 was allowed by Judge Bernier. And the Chief Justice, Christopher Hinkson, had issued 2 orders in 2 proceedings ex Miramoto. That is evidence that the proceedings are still ongoing. And so they had decided on that day that the lands were going to be sold, despite the fact that their application was not even on the trial list, and the fact that litigation is still ongoing and there's injunction on the lands registered, which were registered by consent before Judge Bernier, who made it very clear to me that until the litigation is not over, the lands will not be sold. And that's what the purpose of the injunction is. So when you have a justice of the court and lawyers as officers of the court that are not going to even follow their own orders, ignore the order of Chief Justice, ignore the fact that there's an injunction, and then have this person arrested. Try to put yourself in my shoes. What is one supposed to do when your lands are being stolen? If your car was being stolen, what do? You go out and meet the thief? Shake his hands and then hug him? And then tell him, the police is going to follow you, but there's no gas in the car, so you know what, have $30. So when the police follows you, then at least there'll be gas in the car for you. Is this what happens in life? Or do you expect that person to try and put the person down so he doesn't steal the car? And then when you alert this problem to the police, they don't turn up. But when they do turn up, instead of arresting the thief, they arrest the person who's filing the complaint that the car's been stolen. It's pretty obvious what's happening here in Canada. The problem is so extensive that it cannot be solved, I believe, by taking small measures. There has to be a drastic change. There's a considerable number of people who are suffering, who are being ignored. Lawyers are told to walk away because they've been told that this person is vexatious, which is actually a signal to them that you will not get justice. So even if a lawyer wanted to do some justice for me, like one lawyer did, who represented me for a small period of time in the Gateway proceedings, Susan Al-Khatib, she soon realized that she was not going to get anywhere. And then in the end, she was paid by my former brother Majid. Now, if she's my lawyer, and I did not want to pay her because she did not do her job, or she was feeling intimidated by Judge Bernier, then where does it say that Majid has to pay her bill? That is a direct conflict of interest. These are very basic stuff which I'm telling the world here. It's happening right here. It's not some third world country. It's happening in Canada. And so, to move on to the next point, which is 5, court intimidation. When the sheriffs have been alerted to a problem, it is their duty, whether it's a person going to the counter, there should be no need for the sheriff to be standing 3 feet away. That is not needed. A person is not raising one's voice at the counter. He's making a civil inquiry. A person who's educated enough may be a little bit frustrated. That frustration is also felt by the person on the other side of the counter because they know that something's not right here. They want to do something. They want to help you. But simply offering, words of sympathy is not sufficient. You need to report this matter to the RCMP if you feel that the justice has not followed the Supreme Court rules, or the order of Chief Justice has been ignored by a judge of that court. So the matter has to be investigated, and the sheriffs have to alert the RCMP that there's a problem occurring here. No good them just saying, oh, call the police, because they know that they're not going to turn up. Because a person who is now trying to correct the system has been tagged in some way. So no one's going to listen to him. So they just make statements for the sake of making the statements. Just like Judge Murray had made the statement that he was going to release the funds to me. When there's only 2 people within the proceeding, one person has been released the funds because he's remaining silent perhaps, or perhaps he's been entrapped, or perhaps he feels if he speaks out he's going to lose a lot more. But I think he's going to lose far greater by now remaining silent. You need to speak out, Majid. I think you know what's happening. I think you realize what's happening here. I think you have for quite some time. You still have an opportunity, considering the circumstances, that I'm giving a judge an opportunity to apologize to me. I'm certainly in this kind of situation, I can give you one further chance. But it has to come from you. It has to be genuine. You can do something to have my funds released, because they are my funds. You can also return some of that money as part of a settlement, which I'm willing to give under these circumstances. You don't deserve it, but I'm willing to do that. So the sheriffs should not intimidate. That's actually a criminal offense in the courts. So to move on to the next point. How does one... So this is point number 6. It's crimes within the courts. How does one report crimes within the court? Well, a superstore, if a crime occurs, you pick up the phone and you call the police, and they immediately come. But in the courtroom, it's not that simple. The courts are considered to be a place which is pure. The sanctity of the court is all about having faith in a legal system. So when a person calls the police or reports a crime within the courts, it is often ignored. Where a sheriff will say, well, the matter went before a judge. When they realize that the matter went before a corrupt judge. When they realize this, based upon the knowledge that I have actually shared with them on numerous occasions, they need to investigate this matter internally and then have the report sent out to the RCMP, and the RCMP can then investigate further through Crown Counsel, where the person who is being victimized doesn't have to pay for further applications. One pays for a service. That service is being denied to victims of fraud in British Columbia. I would like to think that this problem is mostly in British Columbia. I hope it's not across Canada. I think some of the problems that Canada has have originated from British Columbia because of old school thought. The thought that we once had these policies and models that were used to control nations because the British Empire was being expanded. Those kind of policies still are being applied now, and they've been downgraded to a level that it's not openly done, so it's still concealed, and it's done against everyone who speaks out for justice, who's trying to do a positive thing, where politicians are perhaps working under fear that if they speak out, that they may lose their position, where a RCMP officer may be afraid that if he speaks out, he may lose his job. We live in a nation where I think some police officers who are women are feeling harassed by men within the police force. No one wants to talk about that. And then when the person, a police officer who's a lady, wants to have justice, then they file a claim, thinking that they're going to get justice in the courts. That's kind of what I have done, because you all think that the courts are about justice. So I filed a claim. And then I was declared vexatious by people who want to conceal the fraud. How can one be vexatious when one is defending an action commenced against him? This is just common sense. I have the right of defense, don't I? And so I'm declared vexatious by Justice Verhoeven. One only has to look at the proceeding S147600, which was a petition. It was not a notice of civil claim, in which I grouped up all the various people, including APEC BC in one group, RCMP in another group, and so forth. Because all of these individuals had a responsibility to investigate the fraud, and they did not. So the fraud is now expanded, just like cancer in a patient. It starts from one cell and it grows, and then eventually, if the treatment does not work, the patient dies. This nation is the same fashion will not exist, because the corruption is so extensive that it cannot be corrected. And so at the world level, the position of Canada will be descaled by the United Nations. And I believe they have done that recently, considering the residential schools issue. So report the crimes in court. It's your duty. And that is not something that you can ignore, because the sanctity of the court is all based upon decency of people, in particular the justices of the court. I think Judge Murray is aware. In the cost application of October 20th, 2017, I filed my response. It clearly indicates, as part of that cost application, that my action, S123329, is now being dismissed. And it's being dismissed after the lands have been sold, which means that they've breached the injunction, because the litigation is still ongoing, and Judge Murray is aware that the lands were sold on the basis, as admitted by her, that all matters have been concluded. You clearly now know that you have to do the decent thing here. I did apologize to you on that day because of the events of me reporting a crime were not being investigated. I alerted you to protect your position as a judge, because when a lawyer goes to court and deceives you or deceives a justice, the people who are before the court have a duty to protect the position of the judge. That is what I was trying to do. You should not have arrested me, but I considered that as a huge mistake because lawyers were deceiving you. But then on June 22nd, you started looking at the Justice Verhoeven order. And I know it's difficult because one judge has now made an order and you feel that you have to follow suit. But you know, based upon my response, and based on the fact that in the cost application, my action is still being dismissed because litigation is still ongoing. That is evidence, and you can take the appropriate action. And you clearly stated to me on that day that my funds will be released. So kindly release those funds, and you can offer an apology because that's the decent thing to do. It's not written somewhere that a judge of the court cannot apologize to a victim of fraud. And the same applies to other people within the court system. One can only go so far, and I think I've gone all the way and beyond. As a decent person, I have actually tried to reach out to every person within the court system. And so matters have to be resolved quickly on the gateway matter, and my funds have to be released. And I'm appealing to at least 5 lawyers who actually were paid some funds to act in the gateway matter. I think you are fully aware what's happening here is totally incorrect. And I can mention you by name, but I'm not going to do that. But you will be given a copy of this video. It's on YouTube, and an email will be appealing to you to come forward. Work on a pro bono basis. Work with me in the realization that there's fraud taking place, and as an officer of the court, you are duty bound to report that crime and investigate the matter by assisting me. You can file a complaint to the RCMP. The fact that it's coming from a lawyer will have greater importance. And so, essentially speaking, one has to understand one concept, which I'm going to talk next under item number 7, which is deference. Deference is an important part of our nation. It's the respect that one has for the justice, for the police, for the priests. A priest has to be respected for the duties that the priest has in protecting the interest of the religion. That is called deference. The justices are no different. As people have taken the oath of allegiance, one has to have deference. And that is the deference that you're giving to lawyers as officers of the court. But that is not a means for you to ignore the fraud. It's not a means for a person to go there because one is a lawyer that he or she will be listened to more when the fraud is being done. The justices have to be aware of the fact. Judge Bernier clearly made the order in the proceeding S111030, alerting Lawson Lundell and the lawyers there not to state in correspondence that Mr. Kuldip Singh Randhawa, which is me, cannot finance. So when that order was made, clearly that indicated that some improper actions were taking place. So when the order was made, did you hold the lawyers in contempt, Judge Bernier? Because really that was actually an act where a person has committed a fraud, where he has misled his own client. And that duty is always with you, to hold people in contempt. So that deference does not exist when a person has done fraud in court. Under those circumstances, people will be frustrated and they will often raise their voice. Because when you don't want to listen to the truth, you want to listen to lies, I think it's sometimes better to raise one's voice. Just as someone's car is being stolen, you don't expect him to be civil in that situation. So going on to the next point is 8, contempt of court. That is where a judge or a self-representing litigant can solve a problem. Once again, that has to be done without any abuse. Because when you can steal lands, worth millions, and then extort the money from one person, because that is exactly what it is. You're stealing the person's shares, and then you're selling the lands which actually cannot be sold because there's only one shareholder, according to the order of Judge Bernier that was made December 31st, 2013. When you consider the reasons of judgment, the facts are very clear. Despite the fact that it is actually an instrument of fraud, but taking the true facts within that document, even though it's an instrument of fraud, just considering the facts which the judge has accepted, ignoring the bias because that's not reflected in that reasons of judgment, and just considering the accounting numbers. It's like adding, 1 + 1 is 2. So the order was made that Manjeet has 1 share if he contributes $1, and Kuldip has 1 share if he contributes $1. It's a very simple exercise. Just look at my contributions that are in the reasons of judgment that have been allowed by Judge Bernier, and you will see that Manjeet is not a shareholder. And so if he was aware of that, and that was the reason that the judicial inquiry was not done, that was actually ordered by Chief Justice Christopher Hinkson, then not only are you doing fraud in court, you're in contempt of court. You're in contempt of court in ignoring the order of Chief Justice as well. You're in contempt of court because the Supreme Court rules say that the first appearance before a judge has to be a case planning conference. Did you not see my application and a binder of 1.25 inch thick requiring 1 day of hearing? Was you not aware the trial list indicated that my application was only before the court because that was allowed by Judge Bernier back in April, following the order giving conduct of sale to Manjeet, when I could not attend the court because of ICBC accidents. Like, all this is proven within the proceedings. It's very easy to assess. So how is it then that you are not giving me the funds which were made by order of Judge Bernier? Even if you want to hold back the costs which are being opposed, you can do it. Hold that in the court. If my funds are not being released, then the funds that were sent to Manjeet have to be returned as well. What's happening here is you're punishing the person who's telling the truth, delaying the funds, and so causing a duress. It's like almost like telling someone to sign a document. If you don't sign it, we're going to put a gun on your head and play Russian roulette. Or we're going to beat you up. That's what duress is. And I think you're trying to cause duress here, so that Manjeet can then approach me indirectly and have some kind of a forced settlement. Well, that's not going to happen now. Manjeet has to do the right thing here, and so do you. Release my funds without making an application, because you clearly stated the funds would be released. And then I can have the rest of the damages claim, which I intend to proceed in the action S123329, which should not be dismissed. I have no intention of building on those lands anymore. I've made that very clear to you. Because you've caused me so much harm. It's called irreparable harm. I made those statements to you. My desire to build on those lands doesn't exist anymore. But I do want damages. And so the next one is basically 9, which is Court of Appeal. One has to understand that the Court of Appeal is right across the road from the Supreme Court. The justices from the Supreme Court actually end up going to the Court of Appeal. And that Court of Appeal is for errors of judgment, errors of law, or errors of fact. They're not for intentional acts in which criminal offenses have actually occurred. And those criminal offenses, if they've occurred by a judge who was deceived by lawyers, because of the present system is that no one's going to investigate it. These are exceptional circumstances, I think, because everyone fears losing their jobs. You perhaps may feel that you won't be promoted to the Court of Appeal where a justice has not followed the orders of Chief Justice. Perhaps he's told you to not provide justice to me. He's provided the orders, but who knows what the truth is here. So if you're working under those sort of circumstances where you can't even trust your fellow judges who you're now trying to protect, where I can't have respect for the courts because it's not a place where justice is done, then you need to consider this. And the Chief Justice can make another order. I don't want a major retrial. All I want is my funds to be released and the damages. I don't want to build on these lands anymore. I'm considering my position in Canada. I came to Canada as a place because it's advertised in the world level as being a place where justice is done, and it stands for human rights. I came to British Columbia because of my British roots. I didn't think a British citizen will be discriminated against in British Columbia. But that's exactly what's happened. And so the Court of Appeal is not for solving crimes. But I think if by executive order, if the Right Honourable Justice Trudeau or some other lawmaker can make it a law that when you go to the Court of Appeal and the Court of Appeal can be asked to investigate the judge of the lower court, then I can perhaps go there. But I think it's a total waste of time going to the Court of Appeal where everything has already been pre-decided. I've on numerous occasions seen 3 or 4 applications set on a certain day, and all of those applications are denied because it's been predetermined that all of these matters are going to be denied. So they go before one judge in one court. It's happened to me on numerous occasions. A poor fellow in a wheelchair was seeking justice from a judge in the Court of Appeal, where he complained the RCMP officer had abused the situation. I recall that situation, and he was also denied justice. And so lastly, 10, which is felony. Obstruction of justice is a felony. When you have a legal system where crimes are not being investigated, Victims of fraud are being targeted, harassed, intimidated, ignored, assaulted, handcuffed and put in jail, and the lands are sold, and then pushed around by the sheriffs as the person is leaving and he's cooperating fully. All of these acts do constitute obstruction of justice. They're all intended to send a message to the person who's seeking justice: get the heck out of this court. It's not for you. You don't deserve justice because the color of your skin is so much different from theirs. That's racism. When it's happening by a number of people, it's actually racial prejudice. But under law, it's obstruction of justice, and it's actually a felony. And I think most people don't want to take that position. But I think times are changing. I'm just giving you my 2 bits worth, that these activities have to be terminated forthwith so that people can come to the court in peace and in harmony. So with that, that's the 10 points that I wanted to share with everybody. You know, when you have a court system which is not operated under law, it has no jurisdiction to hear the matters. The judges of the court can be held in contempt. Perhaps a separate courtroom has to be created, because it's not being resolved by the Judicial Council. I have actually written to that organization many times. I've written to the Office of the Ombudsman, or the Ombudsperson as it is now considered. I've written to the Law Society of British Columbia. I've written to the Engineering Association. All of these organizations exist, and they're ignoring the law, because it's not the acts, it's the people behind these acts who are not really doing something because of their nature of who they are. And then I think it's time to put an end to this. I think I've said enough. I hope I can reach out to everybody so that change can take place very quickly. Should you wish to contact me, you can do so at kuldiprandhawa5@gmail.com. That's KULDIPRANDHAWA5@gmail.com. God bless.